What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
I'm sorry, if the court is asking whether they could be...
If the president gives an unlawful order, call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Gouverneur Morris said explicitly at the Constitutional Convention, that his coadjutors could be prosecuted. There is an important caveat because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes. The criminal law books are replete. But, I mean, do you agree, is that one check that's available?
Absolutely. And again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the Recommendations Clause, and therefore we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutors, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.